Morning, everyone.
Good morning.
Is everyone here? Morning, Mr. Village.
Morning, Madam.
Morning,
Good
Mr.
morning, Mr.
Robson.
Barrett. Good morning, Mr. Robson.
Good morning. Morning, Mr. Village.
We're all feeling bright and breezy this morning. It was a bit more of a dash getting the kids off to school.
Yes.
All right then. I made it though. Okay then. Welcome back, everyone. The time's 9 o'clock, and I shall resume the inquiry into the appeal made by Dignity Funerals Limited against the decision of Doncaster Council to refuse planning permission for a crematorium, including memorial gardens, car parking, a new vehicle access onto Green Lane, and ancillary works at land south of Green Lane, Brodsworth, Doncaster. And this is the 7th day of the inquiry. Can everyone just check that their mobile phones are switched off or put onto silent? And if the council could send the attendance sheet through the close of play today, please. Hopefully you should have received, Mr. Village, the revised timetable, which has already been overtaken, and the site visit itinerary now. It should have come through yesterday.
Yes, that came through yesterday,
Mm-hmm.
but as you say, it's a bit of a movable feast.
Yeah, it is. I don't think we necessarily need to discuss those at the moment, unless anyone has any issues. I'm conscious, Mr. Village, you said that we'd received Mr. Best's revised tables. Are they in hand? Are they coming through soon? I don't have them quite yet.
They are in hand. I confess I haven't seen them myself. But I mean, I would quite like the opportunity of just looking at them before I present them to the inquiry. But yep. They are done, I'm told.
That's good to hear. Obviously, if we can see sight of those sooner rather than later, that would be appreciated. Thank you. Just also in terms of the additional day, I mean, hopefully we won't need more than an additional day if we keep on track to the timetable today. I think it would be worth fixing that day. I know how busy everybody is, and I wouldn't want to lose that day and have any further delays. So we'll come back to that at the end of today, but if you could all give thought to which day is your preference, and we'll get that fixed in the diaries.
I mean, I could do the Monday. My preference would be the Tuesday. So I just threw that out there.
Okay, I'm pretty flexible. Mr. Robson, Mr. Barrett, is the Tuesday the 1st acceptable?
Yes, ma'am.
Mr. Barrett, do you want to unmute yourself there?
You're on mute, John.
Thank you, Peter. Did you say Tuesday the 1st? Because I think that Tuesday's the 30th.
Oh, hang on.
Yeah. Madam, I'm okay for either Monday, Tuesday or Wednesday, so I'm quite flexible. If Mr. Village has a preference for Tuesday, then I'm quite happy to go along with that.
That's fine. Tuesday, 30th November. Yeah, that's absolutely fine. We'll get that date fixed in diaries then. Thank you. Okay, well, if there aren't any other procedural matters, just to double check, is anyone who wishes to speak today who hasn't already indicated that they wish to do so? No. Okay, then, well, Mr. Village, would you like to resume your cross-examination of Mrs. Sudes? Thank you.
Ms. Sudes, just going back to a point we discussed yesterday, we've been looking at the council's website. The site inspection, I think, took place on the 4th of December. Is that your recollection? 4th of December 2020?
Yes, I think that would be around that date. The exact
Yes.
date, I'm not sure without checking, but yes, it would be around that time.
And the meeting was on the 18th of December.
It was, yes.
And you produced your report prior to the meeting, at least 5 working days prior to the meeting, didn't you?
I did, yes.
Yeah. And you didn't change your conclusions in the report, notwithstanding that you'd been on the site inspection on the 4th of December.
I'm sorry, didn't change my report in what respect with the site visit?
Your conclusions in relation to, for example, the minor effect on openness.
No, I didn't.
No, thank you. Right, thank you.
That was based on LUC's, Miss Oxley's review
Yeah,
of
but
the LVIAs.
But she's made it clear that she regards the issue of openness and the harm and the extent of the harm to be an issue for the planners, for you, and your conclusion was it was minor.
Based on her recommendation, yes.
Based on her recommendation,
yes.
And your own judgment. You didn't blithely you follow her judgment or her view. If you'd thought that it was significant based on your own assessment on the site visit, you would have said so, wouldn't you?
Miss Oxley is the professional. That's the area of expertise. So I took her advice.
You would have said so, given your own professional duties and abilities, wouldn't you, Mrs. Sudders?
Like I've just said.
No,
Miss Oxley,
not like you just said.
Yes,
Would you like
like
to
I've just
answer
said.
the question?
Miss Oxley is the expert. I took her advice.
Mrs. Sudders, I'm going to put the point again, and you are going to answer this question. You are. You would, according to your own professional abilities and duties to the council, have advised the council that you disagreed with her judgment if you thought the effect on openness was significant, wouldn't you?
I would have, yes, I would.
Yes. Yes.
But her advice at the time, I took her advice and I attached my weighting to her advice.
Yes, but you've given the answer. You would have, according to your own professional duty to the council, your own ability as a planner, you would have made clear your disagreement if you thought the effect on openness was significant rather than minor, wouldn't you? Thank you.
It's not my professional ability to be able to make that assessment above Miss Oxley's.
Miss Oxley told us it wasn't for her. She said it was for you in this inquiry, Mrs. Sudders.
Well, I based my opinion on Miss Oxley's recommendations in her report.
Oxley said it was for you, didn't she, Mrs. Sudders?
I based my recommendation in the. I based my recommendation in my committee report based on Miss Oxley's review of the LVAs.
Would you like to answer the question? You will answer.
I think I've answered it, Mr. Village. I think I have.
No, if you answer it again.
I have given you the answer. I made my recommendation following Miss Oxley's review of the LVAs submitted with the application.
She said it was for you in her evidence, didn't she, Mrs. Sudders?
That's what she said in her evidence, yes. And I'm saying my recommendation was based on her advice following her review.
We're going round in circles because you've already...
I think we are, yes.
You're going around because you've already accepted that if you thought she was wrong, you would have voiced your professional disagreement. You've already said that, haven't you?
I wouldn't challenge her professional judgment.
Wouldn't you? You would not have said.
You would
not have said to members.
You would not have said to
members. You would not have said to members. Miss Oxley says in fact, Miss Oxley didn't say the effect was minor. That was your judgment in the report. But you would not have challenged her judgment, notwithstanding that as a planner, it was for you to make that judgment. Is that right?
At the end of the day, it's my judgment, and my judgment was based on Miss Oxley's recommendation and her review of the LVAs that were submitted with the application.
And Miss Oxley conspicuously failed to identify the harm at this inquiry as to openness as significant, didn't she?
She commented that it was minor.
Yes.
And I attached significant weight to that.
Yeah, she commented it was minor at this inquiry, yes. Didn't she?
And so then
why is it that you now change the weight that you give to Miss Oxley? So much weight given to her judgment that you say you wouldn't have disagreed with it before members, but now you apparently attach, you say, well, your own judgment is that it's significant weight, notwithstanding that Miss Oxley says it's minor.
Yeah, that was my judgment, yes.
Mm. Okay.
Mr. Village, you've made your point. I've taken a note of it. Can you move on, please?
Yeah, I am moving on.
Can I just also ask you to be considerate and polite in the way you phrase your questions, please?
Yeah, I hope I am considerate and polite, but I do expect, and I think I am entitled to an answer to my questions, particularly where, as in the case of today, we're under some time pressure.
That's true, but there are ways of asking the question. So if you could move on, please, Mr. Village.
I'm moving on. Alternative sites, that's not a reason for refusal, as we have already noted, is it?
No, it isn't.
And it's not in the council statement of case?
No, it isn't.
And you don't put forward any preferable alternative site?
It isn't the council's responsibility to put forward a preferable alternative site, I believe.
The answer to my question, therefore, is no.
No, because it's not the council's responsibility.
Okay. There's no development plan policy requiring an alternative site assessment to be undertaken, is there?
No, there isn't.
No. Still less, are there any criteria published by the council as to how an alternative site assessment should be undertaken?
No, there isn't.
And there's no requirement at the development control stage identified in the NPPF, is there?
No, there isn't.
No. And those 3 points I've just made are all highly relevant considerations in deciding whether or not this in fact is a good point made by the council. Are you still thinking about that answer, Mrs. Sudders?
I'm sorry, Mr. Village. I didn't realise you were asking me questions. I thought you were making statements.
Come on, Mrs. Sudders, let's not play games. Those are three. Those are three. I don't make statements. This is a cross-examination. Those are three relevant considerations in the determination of whether you make a good point, aren't they? Aren't they?
Sorry, Mr. Village, I really don't know what you're getting at and what you're specifically asking me.
I've just identified three considerations in determining whether or not the council are making a good point. You are making a good point about the absence of what you say is a suitable or an acceptable alternative site assessment. And the 3 points I've put to you are: there's no development plan policy requiring an alternative site assessment. First. Second, still less are there any criteria published by the council as to how such an alternative site assessment should be undertaken. And third, there is no requirement in the framework for such an alternative site assessment to be undertaken at the development control stage. You've assented to each of those propositions. You've agreed with them.
Yes.
Right. Those are all therefore relevant in determining whether or not the point that you're making, such as you're making, if you've got any point in relation to alternative site assessments, as to whether it's a good point or not, aren't they?
They're certainly points. Yes, they are points.
They're relevant considerations, is what I just said. I didn't ask whether they were points. I mean, we can play games till the cows come home. I said they were relevant considerations. And that was a question. Could I have an answer, please?
They are considerations, yes.
Relevant considerations. Relevant considerations.
They can be, yes.
Well, they can be. Well, they either are or they're not.
Yes, they are considerations.
Yes. You see, it didn't hurt that too much, did it, Mrs. Sudders, to assent to that proposition?
No, it wasn't too painful. Thank you.
And 7.51 of your proof of evidence, Mrs. Sudders, you seem to suggest that other greenbelt sites should have been considered in the site selection process.
No, I don't think I'm suggesting that at all.
Good. I can put a light through that. Thank you. Mrs. Sudders, you complained yesterday in your evidence in chief that the council wasn't consulted, and you pointed to some quite ancient Department of the Environment advice or paper on the siting of crematoria, didn't you?
Yes, there is industry guidance, I believe, yes. Specifically encourages working with the councils.
Yeah, and it is of course right that the applicants did consult, when they were then applicants, now appellants, consult with the council in relation to the site. There was in fact a pre-application meeting, wasn't there, at which in attendance was someone from bereavement services from the council.
Yes, that's correct.
Yep.
There was pre-application advice. There was no consultation regarding sites and a site search, where to search. There was no discussion about that.
No, you say there's no discussion about that. There was no criteria identified, as we've already looked at. You didn't identify the criteria which you would require. You didn't identify anything in that. It was left to the appellant to do it.
They were advised to carry out an alternative site search to identify whether there are any alternative preferable sites other than this site within the Greenbelt. And I believe it was to demonstrate part of the justification.
And that's what they did.
And that's what they did.
It may not be to your taste, but you didn't, as we've already identified any criteria. Now, I want to turn to the issue of balance, please, Mrs. Sudders. It goes without saying that from what you have told the inspector, your assessment of balance is driven by a number of considerations. Your assessment as to harm to the openness of the green belt. That's one of them, isn't it?
It is, yes.
And that's something you give significant weight. You say significant weight should be given to the significant harm.
Mm-hmm.
Yes?
That's correct, yes.
Yeah, thank you. Rather than the position as was in your report that the harm would be minor. That's the difference, isn't it?
The harm to the green belt, it's given substantial weight. There's no.
we went through this right at the outset of this cross-examination. Significant weight is given as per case law and the framework. Significant weight is given to the harm, but that doesn't obviate the necessity. That doesn't obviate the necessity to make a judgment as to the degree of harm, does it?
There's no necessity to make to measure that harm. It should be attributed substantial weight according to the framework.
Mrs. Sudders.
Harm to the green belt. This is inappropriate development, Mr. Village.
Mrs. Sudders, we are going back to an issue I asked you about yesterday, and which you gave me a very clear and, if I may say so, correct answer, which is that the issue of substantial weight to the harm doesn't obviate the necessity to identify what the harm is. You can't just give say there's harm and therefore I give it significant weight. You have to say what the degree of harm is.
Any harm should be given substantial weight.
Yes, it should be given substantial weight,
which is what I've done.
But
in my proof.
But it's necessary to to identify what the extent of the harm is, isn't it? And we went through that in your proof of evidence. I took you. Do you remember? Yesterday, I took you to
yes.
Yeah. Are you resiling from the answers you gave in relation to that yesterday? Do you want to change your answers?
I stand by what's in my proof of evidence, Mr. Village, and that there should be substantial weight attached to harm due to inappropriateness, substantial harm due to impact on openness, conflict with one of the three purposes, substantial harm.
Mrs. Sudders, regrettably, I'm going to have to go back to this. And I notice that the time is now 9:24, and I'm just going to note what time this part of the cross-examination, which I have to repeat in light of the answers you've just given, ends, because I don't want to be criticised for overrunning my time. I didn't expect to have to go through this again, so I'm going to start to put the points to you again, Mrs. Sudders, to see whether we get different answers. Could you please go to 7.13 of your proof of evidence? And you say paragraph 148 then allows substantial weight to be given individually to any of those harms to the green belt. The use of the word any means that substantial weight should be attached to each individual harm to the green belt. 721, you say in summary of the impact on openness of the green belt, the purposes of including land in it, para 148 of the framework allows substantial weight to be given to any harm to the greenbelt. This approach is endorsed as appeal, you go on to say. And I put it to you that if there is minor harm to, say, openness, you would give substantial weight to that minor harm. But if the view was that the harm to the openness was significant, say, or moderate, I think moderate was the description I used yesterday, then you would give substantial weight to that moderate harm. Now that is the correct approach, isn't it?
There is harm to the greenbelt, so I have attached substantial weight in accordance with the framework.
Right.
I'm not aware that I have to measure the harm.
Is it because my questions are unclear that you don't answer them, or is it because you just don't want to answer them?
Mr. Village, I'm sorry, but it's all there in my proof of evidence. It's quite clear.
It's not clear. That's why I'm asking you questions.
Sorry,
about.
This is where we.
Well,
disagree,
I'll be stopped by the
This is why we're
inspector.
here.
I'll be stopped by the inspector or diverted away if A, it is clear in your proof and these questions are improper or unnecessary. So let's just carry on. Mrs. Suddies, the correct approach, just again to you, is to identify the degree of harm and attach substantial weight to it, isn't it? Are you simply not answering now, Mrs. Suddies?
Yes, I will answer, Mr. Village. Yes, just thinking. I don't believe that has to be measured, that it's been identified that there is harm to the openness by the very fact that this is an agricultural field devoid of any built form. It's clearly bringing an urban feel into what is currently open countryside, agricultural in use, and I've attached substantial weight to that harm. It harms the openness.
Mrs. Suddies, I'm sorry, we're looking at a general principle here. We're not looking at the way you've approached this particular your assessment of harm in relation to this particular development. We're looking at the general approach. The general approach. Do you understand that?
I do. Yes.
And the general approach is you should, and this is simply as a matter of law and practice, you should identify the degree of harm and then attach substantial weight to it. So that involves identifying whether it's minor, moderate, or substantial, for example, and then attaching substantial weight to that harm. Do you agree or disagree with that approach? Agree or disagree?
I think I would disagree.
Disagree. Okay, thank you, Mrs. Suddies. That's very helpful. I don't think I need to ask you any further questions about that because it goes to the way, but that's the approach you have adopted in your balancing exercise, isn't it?
It is. Yes, it is.
Yeah. Okay.
Yeah.
Yeah. Good. Thank you. So going back then to, so that deals, I think, with the issue of harm. And there's no other harm that you identify, is there?
There's the landscape harm.
But that goes to the issue of openness, doesn't it? It's not a freestanding. You told me yesterday it's not freestanding.
It's not freestanding, no, but it's part of the considerations of any development within Greenbelt, isn't it?
Not freestanding. So are
any
there
other harm?
Is there any other freestanding harm?
Freestanding harm. Sorry, I don't follow what you mean. Freestanding as in
development control terms. I mean, for example, it would have a serious impact on highway safety, for example.
No.
It would adversely affect the ecology of the area. It would be unacceptable in terms of its impact on residential amenity. Those are all freestanding harms. Any other freestanding harm?
Not that you've just listed, no.
Not what I've just listed. Examples. Yeah. Are there any other freestanding harms?
No, not that I can. No.
Right. So should we go and turn to the benefits now, please, Mrs. Sudders? And in relation to those, first of all, economic, you accord this slight, identify this as a slight benefit. And it's a slight benefit, as I understand it, because you're saying that there's no guarantee that local tradesmen would be employed.
No, and that would be for short-term benefit only, and the facility would employ 5 full-time members of staff, so that's why it's afforded limited weight. So
that employment is not, you regard that as limited benefit, do you? Those jobs?
It's a very small number of jobs. It's only slight, isn't it? So, but on the plus side, it wouldn't harm the wider economy. So, in that respect, it weighs in favour. But I have attached it limited weight.
Social 8.5. In relation to the social benefit of the proposal would be slight and is afforded moderate weight, you say. (8.7).
Yes.
And the reason you afford it, you say the benefit is slight, is because at 8.6 subparagraph 2, you say there's no design reason for refusal. However, Miss Oxley makes clear it's the impact on the character and openness of the Greenbelt that is the point at issue. So that is a reason why the social benefit is reduced, isn't it?
No, it isn't.
Well, you say...
No, it was a judgment overall of the 3 points.
Yes, but in response to the above 3 points, yes. You say, and I've just read it out, so I'm not to read it again, you identify a reason why those 3 points should be given more limited weight, don't you?
Just go into more detail. I go into the detail and address those comments.
Yeah, and
the benefits, say, yes.
And you say that those should be afforded less weight because of a design issue.
No, 8.7 is a summary overall of the social benefits, and they're afforded moderate weight overall.
Yes, overall. And why overall is it moderate? Because in 8.5 and 8.6, 8.5 you identify what the benefits are, 8.6 you give your response to them, one of which is that there's a design issue. There's no design reason for refusal, but there'll be an impact on the character and openness of the greenbelt, and that's why the benefit is reduced in your view.
No.
Well, why did you put it in there?
No, overall, it's in response to the social benefits put forward by Mr. Williams.
Yeah.
In his statement.
Yeah.
So
it's
a mod. Sorry, Mr. Village. Didn't mean to interrupt you.
No. I think it was me, frankly, that was interrupting you, and I'm sorry I was doing that. You say just to remind you what you're saying. You're saying it was in response to the benefits put forward by Mr. Williams, and I was saying yes, I can see that is your response, and the response is Mr. Williams puts forward these benefits. One of your counter to the benefits he puts forward is impact on the character and openness of the greenbelt. That's the point in issue, and that's a response to his points.
It's just a response to his points. Yes.
Yeah.
So the 8.7 is an overall balance and weighting of those 3 points. Of those 3 points, point 2. I think it was mainly. I think point 1 is to reduce the travel times. That was in response to the need, the overall need. So there was a weighting. Sorry.
What you have done here is you have infected one of the benefits by double counting some harm, because you go on to undertake the balance of benefits against harm overall later in your proof of evidence, but here you're infecting one of the benefits by introducing some harm to discount it. And that's double counting harm, isn't it?
It's a response to Mr. Williams' social benefits, that it would reduce travel times, and it would reduce travel times, but Mr. Mitchell is saying that there isn't a need, so it wouldn't necessarily be a social benefit.
Yeah, whatever your answer to it is, you're discounting the social benefit because of a concern about design, impact on the character and openness of the greenbelt. That's what you're doing here, isn't it?
No, it's a response to a point. It's simply a response to a point that it would provide a well-designed and high-quality facility.
Yes. Yeah. Well, you've already told me that you thought it was a well-designed and high-quality facility. We had that answer from you yesterday.
And design isn't a point in dispute.
Yes. So why did you introduce this at paragraph 8.62 then?
Because it was in response to Mr. Williams's benefits put forward, which is a response to his point.
Yes. Well, if it's not an issue in dispute, why do you raise it?
Because it's a response to his point. It's simply that, a response to his point. Point 2 of his comments was to provide a well-designed and high-quality facility. So my response was, there was no design reason for refusal. It wasn't an issue.
However, as Miss Oxley makes clear, it's the impact on the character and openness of the greenbelt that's the point and issue. Miss Sudders, we're not blind. We don't just, I'm sorry, we read the whole paragraph in context. And you were making a negative point here, weren't you? You were seeking to reduce that benefit by saying, actually, it has an impact on character and openness.
Miss Oxley was taking issue with the design.
Mrs. Sudders,
that was the point I was making. I was simply making the point that the design wasn't a reason for refusal, but Miss Oxley took issue with the design and its impact on the character of the landscape.
Yeah, she did, and you're counting this as a negative against the positive, aren't you? That's why you include it here.
It's included because it's a response to that point.
Yeah, it's a negative.
It's a response. It's simply a response to that point.
It's a negative to counter a positive, isn't it?
No, it isn't.
I see. And could you turn, please, to Mr. Best's rebuttal proof of evidence, please? And this is the decision in Oxted.
In which
Best rebuttal.
Which document is that?
Mr. Best's rebuttal.
Sorry, I haven't got that to hand. Sorry, Mr. Village, I haven't got that to hand.
Well, I'm going to read out the relevant part of the decision letter, Mrs. Sudders. Have you not read the Oxted decision?
I can't recall it.
It's dated 30th of September 2021, so it's very recent indeed. You would have read it only in the last 3 weeks.
I've read quite a few, Mr. Village. I can't
Mr.
recall.
Robson's here to provide you with some more assistance, I think.
I think provide the inquiry with some assistance, hopefully, Mr. Village. Simply to say, Miss Sudders, I've emailed you a copy of Mr. Best's rebuttal proof of evidence, so that you might have the appeal decision in front of you. I hope that helps both the questions and the answers.
Thank you very much.
I haven't received it yet.
Whilst we're waiting for that, I'll just continue some other questions. In your overall assessment of the planning balance and conclusion, which is at section 9, I don't see any acceptance of the significant benefit to be given to reductions in overtrading in the Western Arc crematoria, do I?
No, you don't.
But you do agree that significant benefit should be attributed to those reductions in overtrading?
No, I don't. I would apply moderate weight.
Okay.
I've now got Mr. Best's rebuttal.
Well, we'll come back to that in a moment. Let me just finish this point. Notwithstanding that you acknowledge that Mr. Mitchell says that there would be significant reductions in overtrading in the Western Arc,
I would still attribute moderate weight.
Moderate weight. Okay. Just as a matter of interest, you don't, in fact, just as a matter of fact, in your proof of evidence, attribute any weight to reductions in overtrading in the Western Arc crematoria, do you?
No, the impact was more about Rose Hill. It's only since this appeal that we've now started talking about the Western Arc more, I believe.
No, you knew that it was part of our case. It's contained in our statement of case.
In your statement of case, yes.
Yeah, and so you would have been able to consider and weigh the benefits of reductions to the overtrading in the Western Arc crematoria in your proof of evidence, wouldn't you?
Possibly, yes.
Yeah, but you chose not to.
The evidence that we got was that there was no residual need for another facility.
And you now accept that that is not the case.
Well, Mr. Mitchell has stated in his evidence that there is significant overtrading, so I'm accepting his comment in his evidence, and I'm attributing moderate weight to that.
Significant overtrading, and he says that there would be significant reductions in overtrading, doesn't he? In cross-examination.
I believe he did, yes.
So
I believe there would still, sorry.
Carry on. Sorry. You believe there will still be?
Well, the moderate weighting, it's couched by the fact that there would still be a significant overcapacity within the Western Arc, not below 80%. So that's why.
Okay, that's very helpful.
Weighting.
So that you don't give it significant weight because the overtrading is not brought below 80%.
That's
that right?
Correct. There would be no qualitative improvements.
Well, there would be qualitative improvements, but they wouldn't get to below 80%.
Right. Okay.
Well, that's right, isn't it? That's your case. Yeah. Why do you say that the need has to be met in full by the appeal proposal?
Sorry, can you explain a little bit more?
Well, your complaint is that the need is not met in full because there's still overtrading. There's still overtrading in the Western Arc following the opening of Brodsworth. My point is simply this: why do you say the need must be met in full by Brodsworth? It's the position, I think, of all three witnesses on need, Mr. Best, Mr. Mitchell, Mr. Hodgson, that in fact there would be a requirement for yet another crematorium in the Western Arc area. So why are you saying that the fact that Brodsworth doesn't meet the need in full itself counts against it?
Well, it would take cremations off the Western Arc, but we don't know if there's not a better located facility within the Western Arc. It's not. Sorry.
Well, again, I don't want to cut across you. If you finished your answer.
No, it's fine. It's fine. Yeah.
I was going to say it is everybody. Everybody accepts that yet another crematorium would be required. Everyone accepts that. So it's a strange conclusion of yours to reach, that because Brodsworth doesn't in fact meet the need in full in relation to all the Western Arc crematoria, then that should count against it in circumstances where everyone accepts yet another crematorium would be required. So I suppose the question is, why does the need have to be met in full for it to be given significant weight?
I don't think it's been demonstrated that there isn't a better alternative site that would better meet the need in the Western Arc.
It's not.
I mean,
we're going around in circles. I put the question very clearly. Why does the need have to be met in full for it to be given a significant benefit? That was the question. All parties agree that yet a further crematorium would be required. So this alternative site point, well, yeah, an alternative site, another site will be required. Everyone agrees that, everyone. But what I'm asking you is a different point. Why does the need have to be met in full? If it meets a need, why does it have to be met in full to be given significant weight in circumstances where everyone agrees yet a further crematorium would still be required? Do you have an answer to that, Mrs. Sudders?
I don't think I do, Mr. Village.
Okay. Oxted, please. You've got the decision letter here, and the inspector's view in relation to the. It's a generic view in relation to the weight that should be given to the social aspect of this proposal. Paragraph 51. He says, however, and this is following on from his assessment of harm in paragraph 50, where he finds that there would be moderate harm from this proposal, to which he attaches substantial weight. So that goes to the very issue we were debating a few moments ago. So that inspector clearly, paragraph 50, that inspector clearly disagrees with your approach, doesn't he?
Yes.
Yes. And paragraph 51, however, cremation facilities meet an essential community need, which in this area is currently not being fully met, either quantitatively or qualitatively, with demand forecast to increase steeply. the proposal would make a significant contribution towards meeting this existing and growing need. This is a need to which I attach very substantial weight. That's the same need, that community need, which you attach moderate weight, isn't it?
Well, reading from this, these two paragraphs, Mr. Village, I'm not fully aware of the situation, the full context of the appeal, so it's something that I would leave to the inspector's judgment in her considerations.
Thank you very much indeed, madam. Those are all my questions.
Thank you, Mr. Village and Mrs. Sidders. Okay, I just really have one point, Mr. Des, in terms of the fact that the local plan obviously has now been adopted 23rd of September 2021. Yes. And I think it would be quite useful for the council to set out just a short statement saying which policies are now relevant to the appeal in terms of the most pertinent policies that would be used in the reason for refusal and any sort of more peripheral policies. I think it might be useful to have that before the inquiry, just for the avoidance of doubt, if that's acceptable to the other parties. It could be agreed with the other parties as well, possibly as an addendum to the planning statement of common ground. So that was really my only point. Would that be acceptable to the other parties, just so we don't leave the matter to any doubt?
Yes, certainly.
Certainly from our point of view as well, ma'am.
Mr. Robson.
Excuse me, frog in my throat. Yes, madam.
Okay, thank you. If the council could coordinate that would be really helpful. Thank you. Okay, Mr. Robson, would you like to commence your re-examination of Ms. Sidders?
Thank you, madam. Mrs. Sidders, do you still have the Oxted appeal open?
I do, yes.
And open at paragraphs 50 and 51. Now, we heard from Ms. Oxley last week that she identified a degree of landscape and visual harm, and you referenced it multiple times during your cross-examination.
Yes.
And you were asked, is there a freestanding reason for refusal on landscape and visual harm? And you said no. If you look, please, at paragraph 50 of the Oxted decision, there the inspector gives the overall degree of harm in respect to greenbelt purposes to prevent encroachment and preserve openness would in this case be moderate, and gives it substantial weight, and Mr. Village took you to that section, along with the harm implicit from the scheme's acknowledged inappropriateness within the greenbelt. There's then a sentence that says, added to this is a moderate degree of further harm to the character and appearance of the area, through the scheme partially closing an open view to the chalk escarpment, adversely impacting upon the setting of the AONB. So the inspector there doing the first part of the paragraph 148 test. Do you have the framework available to you?
I do, yes.
Paragraph 148 says very special circumstances will not exist unless the potential harm to the greenbelt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations.
Yes.
In the Oxted decision, where within that sentence in the framework, very special circumstances will not exist unless the potential harm to the greenbelt by reason of inappropriateness and any other harm resulting from the proposal is clearly outweighed by other considerations. Where does the landscape and visual harm get taken into account?
It comes within the any other harm.
And how do you say that the inspector should deal with the landscape and visual harm identified by Miss Oxley?
It should be considered as part of the overall balancing exercise under the heading of other harm.
Thank you. There was a series of questions about the alternative site assessment. And 3 points were put to you about it being the point to you where there's no development plan requiring a site assessment to be undertaken, to which you said no, no criteria published, to which you said no, and no requirements at development control stage in the framework, to which you said no. And you were asked a question about whether it was a highly relevant consideration, and I think your answer was that it was a relevant consideration to the importance of an alternative site assessment. Do you have Mr. Williams' proof of evidence to hand, please?
Yes. Yes.
Could you go to page 19 of that proof of evidence, please, section 6?
Yes.
Which is headed the availability of alternative sites outside the green belt.
Yes.
You have that.
Yeah.
And paragraph 6.3.
Yes.
It says national and local planning policies do not specifically require a sequential examination of the availability of alternative sites outside the green belt to accommodate the development. This is accepted by the council in its statement of case and by memorial of its statement of case. And then Mr. Williams says, however, as part of the very special circumstances case, it is appropriate to consider whether there are alternative preferable sites available to accommodate the development within the catchment area it will serve. From that paragraph, what do you take Mr. Williams's view, or Mr. Village's client's view, of the appropriateness or otherwise of an alternative site assessment?
That there should be an alternative site search for sites, more preferable sites.
Thank you. Finally, Ms. Oxley's proof, please. And this relates to a number of questions put to you about how openness is treated by the council. And it was put to you that it was put to you in a number of different ways, that no assessment of openness was done by Ms. Oxley. It was put to you that no grading was put to you was agreed to by Ms. Oxley, and it was put to you that Ms. Oxley wouldn't agree to attaching a conclusion about weight to harm to the openness of the green belt. So 3 different ways, which perhaps didn't assist understanding. If you could look at page 8 of Miss Oxley's proof of evidence, please, and paragraph 2.6.
Yes.
And it's started, well, paragraph 2.6 deals with loss of openness within the green belt. She deals in the first half of that paragraph really with the appellant's approach to dismiss visual impact and impact on greenbelt openness, mentions the impact on change in landscape character from open and undeveloped to developed, and then says this: the development would lead to a significant and permanent loss of openness within the greenbelt and west of Long Plantation, which is a strong boundary between the more developed areas to the east and largely undeveloped open land to the west, extending 5 to 6 kilometres to the next more developed area of Thurnscoe and Goldthorpe. The land lies within a swathe of largely intact agricultural landscape and performs a role in safeguarding the countryside from encroachment of land use of a suburban or urban character or urban fringe character, as well as separating more urban areas. So from there, what assessment of openness has Miss Oxley produced to the inquiry?
There's significant harm to the openness of the green belt.
Now, as a planner, as I think was your answer to Mr. Village, your role is to assess the weight that should be given to that. And what assessment did you make of the weight that should be given to that assessment of harm to openness?
Substantial.
Thank you. Just bear with me a second, please, Mrs. Sudders. Thank you. Thank you very much, Mrs. Sudders. Those are my questions in re-examination. Thank you, Madam.
Thank you, Mr. Robson. Mr. Sudders, you can now relax. Thank you very much. Okay. Mr. Barrett, are you in a position to call Mr. Mitra, is it, to give evidence in chief?
I think it would be sensible, Madam, if I call Mr. Mitra and deal with his examination in chief. I think I gave 30 minutes or thereabouts, might be a bit less than that.
Yeah.
If everybody's content.
Yeah, that's fine. Thank you, Mr. Barrett.
Not at all. I'll call him.
Welcome to the inquiry, Mr. Mitra.
Yes, Mitra. Thank you, Chair. Madam.
Thank you, Mr. Barrett.
Mr. Mitra, if you will take up your proof of evidence, I'll introduce you to the inquiry. Your name is Chris Mitra, is that correct?
That is correct, yes.
You're the Managing Director of Genesis Town Planning, and they represent Memoria, the Rule 6 party in this appeal, is that correct?
That is correct, yes.
You personally have a Master of Arts degree in Town Planning. You're a chartered member of the Royal Town Planning Institute with some 36 years experience at national, local government and private practice level. And you've extensive knowledge of a wide range of planning related matters in relation to residential and commercial development, having worked in both the private and public sectors. And specifically at 1.2 of your evidence, you tell us you've been specifically engaged in crematoria development for over 26 years. Is that correct?
Yes, that is correct.
Your role 1.3 is to give evidence to the inquiry, and at 1.4 a professional witness declaration. The evidence you've presented represents your professional opinion on planning related matters based on your knowledge and understanding of the issues, and you believe the facts stated in your evidence are true and accurate. Is all that correct?
Yes, it is.
Mr. Mitra, I'm going to suggest that we take all your evidence as read, but there are a few points that I would like to highlight, and I'll invite you to read them out. We'll even take your summary as read. Section 2 is your background to the case. Section 3 is the site context and character. Section 4 is an assessment of the proposal. At 4.1 and 4.2, you give a pretty uncontroversial description of what is proposed. Is that correct?
Yes, that is correct, yes.
Can I ask you to read paragraphs 4.4 and 4.5, please?
In the light of the above, it is evident the appeal proposal would result in a wholesale change to the character of the appeal site and surrounding area. Not only is the building substantial in size, occupying a significant footprint, but the access road and hard standing areas to include the footpaths, circulation routes and car parking areas all add to the built form on the site. In addition to the provision of landscape terraces, gabion retaining walls, boundary walls and fence screening up to 4 meters high, together with the introduction of native and ornamental planting, results in a significant change to the character of the site. The existing open and uninterrupted character of the agricultural landscape is, as a consequence, significantly urbanized as a result of the changes proposed. Add to this the lighting of the building, both internally and externally, along with the access road and pathways within the site, and the urbanizing effect of the development proposals are significantly exacerbated. These changes would be harmful to the openness of the greenbelt and the character and appearance of the countryside in general. That harm to the openness of the greenbelt is to be given substantial weight in the determination of this appeal.
In the next section, you deal with planning and policy analysis, and to some extent this is a function of the time that it was written, because we now have, indeed within the last month, the adoption of the local plan. Very quick question, did the local plan go through the usual process of independent examination and testing of soundness?
Yes, it did, yes.
And it's now been adopted following the independent report of the inspector making those findings?
That's correct, and there were no changes to the greenbelt boundary in the context of the appeal site.
At 5.8, and I know this matter is on the to-do list by Mrs. Sudez, is to draw up the relevant policies that are of particular relevance and application to the case now. But you reference in your 5.8 the emerging local plan, now adopted local plan, and policy 1 subparagraph 6 that deals with greenbelt.
That's correct, yes.
Very briefly, Mr. Mitter, if you would the appeal proposal be consistent in accordance with that policy, or would it conflict with the policy?
It would conflict with the policy.
Thank you very much. 514, please, of your evidence, page 9. I'm going to ask you to read these because you draw attention to planning policy guidance and the specific reference there. Can you just read the paragraph 14 and 15 of section 5, please?
Thank you. The planning practice guidance is clear that in assessing the impact of a proposal on the openness of the greenbelt requires a judgment based on the circumstances of the case. It confirms that the courts have held that a number of matters need to be taken into account when making such a judgment, namely, the openness is capable of having both spatial and visual aspects, the duration of the development and its remediability, taking into account any provisions to return the land to its original state or equivalent state of openness, and the degree of activity likely to be generated, such as traffic generation. In this respect, the openness of the site would be irreparably lost both in spatial and visual terms. The uninterrupted and open view across the site would change significantly from one of an open landscape to one of built form, urban features, tree belts and landscaping, lighting and associated activity. The built development, together with all the requisite infrastructure and continued use and activity, would be permanent, and therefore the loss of the land would mean that the current agricultural use would never realistically be reinstated. In addition, there would be a significant and noticeable change in activity across the site arising from the proposed use, including the movement of people and vehicles on a daily basis, where currently there is none. And in short, the proposal would lead to significant harm to the openness of the greenbelt, both spatially and visually, through the introduction of built form, hard surfacing, landscaping, and the urbanisation of the land, altering irreparably its agricultural and rural character and appearance. The development lifetime of a crematorium is typically in excess of 50 to 70 years, and as such, there is no real prospect of a return of the land to agricultural rural use. As such, both the land and the openness of the site is lost forever, fundamentally undermining the permanence of the greenbelt in this location. The degree of activity based on the appellant's own case shows significant traffic movements throughout the day, with 13 two-way trips for vehicles in the morning peak and 30 two-way trips in the evening peak. These movements do not account for those within the remainder of the day during the inter-peak period, outside the peak period. These will be the most significant, and by the appellant's own evidence will account for 97.5% of all movements. During winter periods, when daylight times are much shorter, the impact of lighting within the site and along the access road, coupled with lights from vehicle movements, will have a significant impact on the character and appearance of the countryside, introducing noticeable activity where currently there is none. This would be harmful to the openness of the greenbelt and the wider landscape of the countryside.
Can I just read paragraph 16 as well? I should have done at the start.
Sorry. My evidence has shown that the appeal proposal gives rise to harm to the openness of the greenbelt and conflicts with local and national policies aimed at preventing encroachment and urban sprawl and to keep land permanently open. In addition, my co-witness, Mr. Taylor, has advanced arguments in landscape terms to address other harm arising from the appeal proposal. In combination, the evidence advanced clearly demonstrates why the appeal proposal should fail. The appellant does not dispute that the appeal proposal amounts to inappropriate development by reason of its nature. My evidence and that of Mr. Taylor shows that in addition to harm to the openness of the greenbelt, there is additional harm to the landscape quality of the countryside. All of the above considerations lead to the conclusion that in planning policy terms, at both local and national level, The appeal proposal amounts to inappropriate development and is by definition harmful to the green belt, and there is additional harm to wider landscape character. That harm arises from the permanent loss of openness and the introduction of substantial built and natural features which further erode the agricultural and rural character of the area.
Section 6 is your planning assessment and planning balance. Again, take much of this as read. Can I ask you to turn to 6.11, please, on page 15, where you have referenced some decision letters which are before the inquiry. 6.11, please.
Thank you. The findings in respect of both the above appeals leads to the conclusion that loss of openness is not merely a product of built form, but also the landscape and hard surface details that accompany the development proposal. They cannot be taken in isolation, and the provision of landscape planting can itself adversely impact upon the openness of the greenbelt, irrespective of the quality and scale of the planting proposed. It is therefore evident that the same considerations apply to the current appeal site, and given the scope of works proposed and the level of planting proposed, a conclusion that the openness of the greenbelt will be harmed carries substantial weight. The inspector also considers whether the need for a crematorium in this case is sufficient to amount to very special circumstances. The conclusion at paragraph 70 confirms that the need case is not compelling, that he is not persuaded that the benefits of the development in terms of meeting any local need outweigh the harm to the greenbelt.
In 6.12, then, you reference an appeal by Memoria itself in respect of an appeal in Kent. This was a greenbelt site, is that correct?
That's correct, yes.
And you reference then about halfway down of 6.12 the intended catchment population within the minimum distance catchment area as defined and explained by Mr. Hodgson in his evidence. There were some 220,000 people, is that correct?
That's correct, yes.
And that appeal, nevertheless, was unsuccessful. The inspector not persuaded that those amounted to very special circumstances. What is the identified need in the minimum distance catchment population that concerns this appeal?
In the 30-minute catchment population, it's a figure of just under 22,000. And that's out of an overall population figure of 120,000, so substantially below what appeal decisions have regarded as being appropriate.
And just one factor, if I draw your attention to 6.16, you reproduce the search area, I believe it is, of the appellant in this particular case.
That's correct, yes.
And you've identified the Memoria site, which is either in or on the boundary of that area of search. Just remind us, we know that the Memoria site is not a greenbelt site, is that correct?
That's correct, yes.
Was there any discussion or identification of the Memoria site in the area of search exercise conducted by these appellants?
Not to my knowledge, no.
Thank you very much. Your section 7 is your conclusions, and you draw the conclusion at the very end of that section that for the reasons set out in your evidence, you invite the inspector to dismiss the appeal. Is that right?
That's correct, yes.
Thank you very much, Mr. Mitra. Managed to shave off 10 minutes. Madam, that concludes my examination in chief of Mr. Mitra.
Thank you, Mr. Barrett. The time saving is appreciated. Okay, then, Mr. Village.
That might be a convenient moment, Madam, for a break. I suspect Mr. Village has a couple of questions.
That's why I wanted Mr. Village on screen, just to discuss that, yes. Mr. Village, would you like to have a break before commencing cross-examination, or are you ready? Are you in a position to commence and then have a break part way through? Do you want to unmute yourself, Mr. Village?
Sorry, yes, I thought I had. Yeah, I mean, I think now's a good time to have a break. We've been going for an hour and 20 minutes. So we can have a 10-minute break, perhaps.
Yeah, that's fine. So 10:30, is that sufficient for everyone? Okay, we shall adjourn until then. Thank you. Welcome back, everyone. Shall resume the inquiry. Mr. Village, are you ready to commence cross-examination of Mr. Mitra?
Yes, thank you very much indeed, Mr. Mitra. Madam, Mr. Mitra, have you actually been onto the site?
Yeah, I have, yes.
Yeah. And it was your assessment which has fed in to your planning balance, that at paragraph 3.2 you say that the appeal site forms part of much wider open arable fields which retain a distinctly open and rural character with far-reaching and long-distance views. Yes?
That's correct, yes.
That is your professional judgment, which has informed your judgment about balance. Is that right?
That is correct, yes.
Yes. Thank you very much. Those are all my questions.
Okay, thank you, Mr. Village. That was very brief.
My extensive re-examination, madam.
Well, I was yeah, I didn't actually have any questions either. So, Mr. Barrett, is there anything to re-examine?
I mean, just to point out, madam, that of course I have come within my the 2 hours that you requested of me.
You have, Mr. Village. That's very, very much appreciated. So that's fine. If you want to keep that short, that's up to you. I didn't have any questions. Mr. Barrett, did you have any points in re-examination?
Very short point derived from Mr. Village's very succinct point. Your assessment in 3.2, does that feed into the overall assessment that one makes under the framework, paragraph 148? That's your assessment where there's a degree of harm over and above definitional harm. Is that correct?
That's correct, yes.
Well, Madam, may I just say that? So such a leading question. I can't believe that my then friend has, with all his countless years and frankly as many years experience as me, would lead on effectively one question asked of the witness and would ask a leading question in re-examination like that.
Perhaps you've taken Mr. Barrett by surprise, Mr. Village. Mr. Barrett, would you like to rephrase the question?
Your assessment at 3.2, where is it relevant for the inspector's assessment of the case?
It's in terms of assessing the wider impact of the site, both in terms of its spatial and visual context. In essence, the harm from the development that would arise in this particular case is predicated on that specific character and appearance of the site.
Now, obviously, Mr. Village's question was directed to your professional judgment being informed and reflected in your 3.2. Is that something you're content for the inspector to form her own judgment about on her site visit, I think tomorrow?
Yes, absolutely. And the inspector will see those elements when she's on site.
Thank you very much. Mr. Village, I see your hand is still up. I don't know if that's intentional or not.
Is that a legacy hand, Mr. Village?
It was a legacy hand. It's actually out of shock that the re-examination should be 3 times longer than the cross-examination.
Well, there you have it. Thank you very much, Mr. Mitra. I have no further questions of you.
Thank you very much. Well, it was a very short contribution to the inquiry, but thank you nonetheless. Okay then, let's have a look where we are now. Mr. Village, are you ready to do examination, Chief Mr. Williams?
Yes, I am indeed, and I'd like Mr. Williams to join us online if he would, please. And Mr. Williams, I don't know where you are, to be honest. somewhere in the United Kingdom, I imagine.
In Worcestershire, yes.
In Worcestershire, are you? Okay.
Yeah.
Very good. Well, I hope.
Well, welcome to the inquiry,
as nice as it is in London. Good. Okay. So one proof of evidence from you, Mr. Williams. No rebuttal. Your qualifications. I'm just going to introduce you to the inquiry, if I may. You're John David Williams. You hold a Bachelor of Arts degree, honours in Town and Country Planning, and you're a member of the Royal Town Planning Institute. Is that correct?
That's correct, yes.
And you're director at and the owner of Planning and Development, and your practice undertakes a broad range of professional town planning consultancy work, advising private developers, landowners and local authority clients, and you've over 30 years experience in the planning sector. You've given evidence at examinations in public, local planning inquiries and Section 78 planning inquiries and hearings. You advise clients on a wide range of planning matters, including the preparation and submission of planning applications, advice on development management matters, policy formulation, and the promotion of land through the local plan process.
Yes.
Dignity have been your client for approximately 15 years, during which time you provided advice on the identification of sites for new crematoria and the preparation of planning applications, including in relation to the grant of planning permissions for a crematorium on land in the Green Belt in Dartford and on greenfield sites in Corby and Weston-super-Mare. In addition to a planning consultancy role, you've represented the appellant to negotiate commercial terms for the acquisition of the appeal site as well as land at Corby in Northamptonshire. Mr. Williams, do you confirm that the evidence which you've prepared for this appeal is true and that it's given in accordance with the guidance of your professional institution and represents your true and professional opinions?
That's correct.
I think we could read we can identify the scope of your evidence on page 4. I mean, I don't think we need to read any of that out, but it's therefore this has all been read by all the parties over the past few weeks. So I'd like you to turn to the policy considerations which are set out from, I think, effectively page 9, the development plan, other material policy considerations. Do you want to summarise very briefly those considerations, Mr. Williams?
Yes, so for development management decisions.
Okay, hang on a moment, Mr. Williams. Just wait a moment, please. There seems to be something not particularly right about your microphone, and I don't know whether it's because it's too close to your mouth or not, but it sounds rather.
Is that any better?
It's a bit better. We'll see how we go on. If others are feeling the same, but I just. Well,
is there still a problem with it?
That's better. I think that's better. Are you happy with that, madam?
I am, yes, thank you.
Okay, carry on.
Yes, sorry, Ma'am. I'm actually wearing these clumsy headphones because the speaker on my laptop fades in and out. So I thought hopefully this should be better than the alternative.
Okay, you sound very clear now. Thank you.
Good. So development management decisions are taken against policies in the recently adopted Doncaster local plan, September 2021. Full weight can be given to these policies for the purpose of determining this appeal. The relevant local plan policies are set out on pages 12, 13 and 14 of my proof of evidence. The refusal reason for this appeal quotes policies which are now replaced by the new local plan. Insofar as the sole reason for the refusal relates to inappropriate development in the Green Belt, there is no difference between the old and new policies, which follow NPPF advice. The NPPF July 2021 version sets out government's planning policies for England and how these should be applied. It reiterates that planning law requires applications for planning permissions to be determined in accordance with the development plan unless material considerations indicate otherwise. The NPPF is to be read as a whole, including its footnotes and annexes, and it may be a material consideration in making planning decisions. And the NPPF carries forward the presumption in favour of sustainable development and reaffirms that this sits at the heart of the framework. Guidance in support of the rural economy is set out in part 6 of the NPPF, and I've drawn attention to paragraph 84 bracketed D, which says that planning decisions should enable the retention and development of accessible local services and community facilities. The NPPF also says that planning decisions should support the sustainable growth and expansion of all types of businesses in rural areas through both the conversion of existing buildings and well-designed new buildings. Paragraphs 126 to 134 emphasise the importance of good design and the creation of well-designed, beautiful places, which is now at the heart of the social objective of the planning system per paragraph 8 of the NPPF. And paragraph 174 requires developments to contribute and enhance the local environment. The appeal side, as we've heard, has Greenbelt policy status. The guidance on development in the Greenbelt is set out in chapter 13 of the NPPF. And at paragraph 137, it advises that the fundamental aim of the Greenbelt policy is to prevent urban sprawl by keeping land permanently open, and that their essential characteristics are their openness and their permanence. And the 5 purposes of the Greenbelt are set out at paragraph 138. Paragraph 148 of the NPPF advised that when considering a planning application in the Greenbelt, local planning authorities should ensure that substantial weight is given to any harm to the Greenbelt. Very special circumstances will not exist unless the potential harm to the Greenbelt by its inappropriateness and any other harm is clearly outweighed by other considerations. My evidence considers the harm to the Greenbelt, followed by consideration of other matters which have potential to result in harm, and finally using a balanced judgment whether Greenbelt harm would be outweighed by the need for the proposal and its related benefits, which in turn would amount to very special circumstances. I also, in chapter 5, section 5 of my brief, refer to the legislative framework and guidance which is outside of planning policy. The development must comply with the Cremation Act and is DOE guidance on the siting and planning for crematoria. Whilst these do not form part of planning policy, they are relevant to the determination of this appeal. The 1902 Act imposes restrictions on where crematorium can be sited from residential properties and roads, and the measurement is they must be further than 200 yards from a road and 50 yards, 200 yards from a residential property and 50 yards from the road. We've also got FBCA guidance, which has not been endorsed by government, but it is recognised as a valuable piece of advice by the crematorium sector. And just a comment about the status of the CMA inquiry report. Again, this is not planning policy, but it is helpful and it is relevant for the purpose of any discussion on the qualitative element of need. To that extent, it is material, but it doesn't carry the same weight as planning policies and the up-to-date development plan.
Good, thank you very much. I think that takes us to your section 6, and then this is the availability of alternative sites outside the Greenbelt. Contrary to her evidence, Mrs. Sudders now maintains that she's not suggesting that you should have looked at alternative Greenbelt sites. So anyway, this section is your assessment of alternative sites outside the Greenbelt, and just to address a point which was made in re-examination by Mr. Robson, I put to Miss Sudders a number of points that there is no development plan policy requiring an alternative site assessment. Still less are there criteria published by the council as to how such an alternative site assessment should be undertaken, and there's no requirement at the development control stage for such an alternative site assessment to be undertaken in the framework. And she agreed with all of those propositions, and I asked her to confirm that they're all highly relevant in the determination of whether her point in relation to alternatives was a good one. And I think eventually we got to a position where she assented to that. Just so I'm clear, first of all, at the outset, at the get-go, did you undertake, or were you instructed to undertake, an alternative site selection process on behalf of the appellant Dignity?
Yes, we did that, and that was one of the first pieces of work I did when I was appointed by Dignity on this particular matter.
And when was that? When did you undertake that?
That was in 2016. I think it was actually November 2016.
Okay. And there was a meeting with you and the council, in fact, Mrs. Sudders, which was a pre-app in 2019, I believe.
Yeah.
And the council said that they would expect an alternative site assessment to be undertaken. So at that stage, had you already undertaken it?
Yes.
Did you undertake another one for the purposes of the planning application?
No, we didn't.
You relied on the one that you'd already undertaken in 2016. And have you since then revisited that exercise for the purposes of this appeal?
I have. I've recast the site search exercise, and that's dealt with in section 6 of my evidence.
Right. I mean, we're doing just to deal with some what one might just swat away a few other points that are made in relation to this. One by Mr. Mitra in his proof of evidence, where he points to the site selection plan and points out the appeal site lies outside the area, site search area. See page 17 of Mr. Mitra's proof of evidence. Does this point go anywhere? What's its relevance, if any, and what weight should be given to it?
I don't understand the relevance, to be quite honest with you. You know, the plan that's referred to, it is a plan which shows the broad target area that we were looking at back in 2016, once Dignity had themselves identified that there was a need for another crematorium north of Doncaster. And the task which we completed then was to look within that general broad area. We looked at opportunities which were beyond the greenbelt, and we also looked at opportunities within it. And it is true that some of those opportunities were beyond the line that's identified on that plan, but not significantly beyond it.
Yeah. I mean, if you look at the plan which Mr. Mitra produces at page 17 of his proof, the appeal site lies just outside the red dotted line. I mean, what do you have to say about that in terms of that? I mean, is that red dotted line, was it regarded as being an immutable, fixed line?
No, it wasn't. You know, we looked at all opportunities to the north of Doncaster. It was not meant to be a line that we were not to cross.
Yeah. Okay. Anyway, you'll no doubt be asked questions. I don't think I'm going to take time now asking you to go through your site selection process. Other than really, I suppose, in general terms. No, I'm just going to leave it to my learned friends. If they've got any points in relation to that, they can ask you. So I think probably takes us to section 5, and sorry, section 7. Which begins on page 33 of your proof. And would you like to summarise this section of your proof, please?
Yeah, so this is the assessment of the development, having gone through the process of setting out the relevant policy framework. I explained there that in reaching conclusions through this part of my proof, I've drawn upon advice taken from Mr. Best and Mr. Lathbury, which demonstrates that there is a need. And I've also taken reference to Mr. Kirkpatrick's evidence, and I've also had regard to the points that he's made in respect of harm to the openness at paragraph 7.10 of his proof. I consider that the harm to the greenbelt and any other harm, and having done so, I then assess whether other considerations clearly outweigh the harm and constitute special circumstances that would support the development. Going through that exercise, I remind ourselves what the purpose of the greenbelt is on page 34. I then examine the very special circumstances case. In the first instance, I examine the harm associated with the development, which I attach substantial weight to, and then identify the benefits of the development, which I subsequently go on to just make a judgment clearly outweigh the harm. The harm associated with developing in the greenbelt is set out at paragraph 7.8. I also then consider how the development will impact on openness through encroachment, and that's set out in paragraph 7.9 through to F4410. And then I consider the adverse impacts and how to weigh those in the balance, followed by an examination of the benefits of the development. And those benefits are broken down into addressing an unmet need, which I've described in 7.18 as benefit 1. And then benefit 2, that's paragraph 7.20. I consider the economic benefits, the environmental benefits, the reference to biodiversity net gain. I set out in paragraphs 7.23 to 7.26. And I consider other benefits, which include qualitative improvements with an enhanced offer by reference to the CMA report, and increase in public access to the Greenbelt.
Yes, I mean, on the question of public access, could you tell me what the position is in relation to public access, please? I mean, is there any public accessibility to the site at the moment?
No, there isn't. There is a matter which we've which came out of Miss Oxley's evidence, which we have looked into over recent days, and that is in respect of the access onto the land from a lay-by on the northern side of the A635 Barnsley Road. You may recall that Miss Oxley referenced that in her evidence, and there was discussions about views towards the site from that particular viewpoint. And I think it is a viewpoint, ma'am, which you intend to look at on your site visit tomorrow. We were unsure whether there was a public right of way onto that part of the site, so we have looked into that and taken it up with the landowner's agent, Savills, who's spoken to their own solicitor and who's also spoken to the council's right of way officer, and Mr. Stuart Horrocks. And we've had an email, we've been sent an email from Mr. Horrocks dated the 18th, which does confirm that there are no definitive rights of way across the land adjacent to the Barnsley Road, or indeed across the whole of the application site.
Okay. Just examine for a moment the issue of social benefits. We've looked at the Oxted decision. That I referred to that in cross-examination of Mrs. Sudders. What is your view as to the weight to be given to the introduction of a new facility which provides choice and adds to the ability of people to access crematoria in the Doncaster area?
Well, my view, and I addressed this in the planning balance table, table 1 in my proof of evidence, is that that rightly should be considered as a significant a benefit which should be given significant weight. Through the development, it will be a reduction in travel times for people who need to access crematoria, and it will provide greater choice, which is one of the strong recommendations that came out of the CMA inquiry. I would like, if I may, Mr. Village, just like to make a correction to some of the text that I have put in that table on the row which deals with sustainable development and the social objective. If you look at that, the opening sentence under that heading, I do need to correct because the reference to a significant population needing to travel in excess of 45 minutes. I don't think I've got that right. It doesn't reflect the evidence in Mr. Best's proof. So I feel it should be corrected to the effect that for a significant population, the appeal site would become the nearest crematorium. Hopefully there won't be a problem in making that change because it still allows me to reach the same conclusion under this heading, which is that there is a benefit to which significant weight should be attached.
Okay, thank you. Yes, the economic benefits. Again, that was given minor weight, I think, by Mrs. Sudders. Do you agree with her assessment of that?
I wouldn't describe that as a minor weighted benefit. It is a job creating economic. There will be economic benefits. So I think in my planning table I've attached moderate weight. I think. Let me just check. Yeah, it's a benefit with moderate weight and economic objectives.
Yeah. Thank you. Right. I think that probably deals with that section. So do you want to turn to your summary and conclusion? Just read section 10 if you would.
The decision notice contains a single reason for refusal. The reason for refusal states that the development constitutes an inappropriate form of development in the Greenbelt, and very special circumstances have not been demonstrated to outweigh the harm. So that the development is therefore contrary to core strategy policies CS3 and UDP policies ENV2 and ENV3, and paragraphs 1.43 and 1.45 of the framework. It is now agreed that policy ENV2 is not relevant policy for the determination of the application. In essence, the Council's case is that the development represents inappropriate development in the Greenbelt. Harm will occur to the Greenbelt by way of openness and encroachment. No other harm will occur beyond the harm to the Greenbelt, and that's agreed with the Council statement of case at paragraph 33 to 35. It is suggested that very special circumstances do not exist to outweigh the harm that arises. This is principally because of the Council's contention that there is insufficient need to support a second crematorium once the Barnby Dunn scheme has been developed. The definitional harm of the Greenbelt to the Greenbelt to which significant weight should be attached is not disputed. I have considered the harm to the Greenbelt, followed by an assessment of other matters which have potential to result in adverse impacts. Finally, I exercise my judgment as part of the overall planning balance to assess whether these other considerations and the benefits of the development clearly outweigh the harm to the greenbelt and any other harm, and therefore constitute very special circumstances which would justify permitting the development. I recognise that there is some harm to one of the greenbelt purposes, namely encroachment, because encroachment is an inevitable consequence of developing outside a settlement. In other respects, however, the development does not give rise to any other harm because the development will not result in visual or landscape harm. And there are no technical reasons in terms of flood risk, highways and design to refuse planning permission. I have identified the following considerations which together constitute very special circumstances that outweigh the harm. The benefits considered collectively demonstrate very special circumstances to outweigh harm to the greenbelt openness and the area's character and appearance. Albeit in my judgment, the clear need for the development alone would be sufficient to establish very special circumstances. In respect of need, there is a quantitative and qualitative need for a new crematorium arising within the catchment area which is served by the development. This is detailed in proof of evidence of Mr. Best and Mr. Laftley. In Chapter 6, I consider the availability of alternative sites and conclude that there are no preferable alternatives beyond the greenbelt to satisfy the identified need. In respect of social benefits, the development will enhance community facilities in the local area and will reduce the need to travel to a crematorium facility. The development will also positively enhance the beneficial use of this part of the greenbelt, where there is presently no public access. Its memorial gardens and its peripheral walks will be open to the local community and crematorium visitors alike, and this will be a positive community benefit. In respect of economic benefits, I attach moderate rate to those benefits associated with the investment in a rural business. In this case, both direct and indirect economic benefits are likely to arise from the development. The development will create jobs and growth in an appropriate location, which is convenient to the market it would serve. On the environmental benefits, the development will result in 16% biodiversity gain, which is a significant overall enhancement of the quantity, species range, age, and ecological diversity of native vegetation within the site. This would result in a significant beneficial effect in arboricultural and biodiversity terms. Whilst it's not necessary to undertake a sequential test to identify the availability of preferable non-greenbelt sites for the development, I have demonstrated that there is no preferable site available to meet the identified need. Applying the test at section 38, bracket 6 of the 2004 Act, the development complies with the development plan because very special circumstances exist which outweigh the harm of developing within the greenbelt. In my judgment, there will be no harmful urbanizing effect of the rural character of the area due to its low density, its low profile building within a substantial landscape framework, which is on a well-contained site. Planning permission should therefore be granted unless material considerations indicate otherwise. In this case, there are no material considerations that turn against the grant of planning permission. To the contrary, the compliance of the development to the NPPF further reinforces the case for granting planning permission. Indeed, having regard to the totality of the policies in the NPPF and the local plan, the development is sustainable development when looking at its social, economic and environmental credentials in the round. The adverse impacts of development, taking into account the considerable importance and weight to be given to harm to the Greenbelt, do not significantly and demonstrably outweigh the benefits. Overall, I conclude that the development constitutes an environmentally, socially and economically sustainable form of development that accords with the NPPF and the development plan as a whole. I therefore conclude and respectfully request that the appeal should be upheld and planning permission should be granted.
Thank you very much. I've got no further questions for you. You'll be asked some questions now by my learned friends. Thank you.
Thank you, Mr. Village and Mr. Williams. Mr. Robson, are you ready to commence cross-examination?
Yes, ma'am.
Thank you.
Good morning, Mr. Williams. I was expecting good afternoon to you, but you can see and hear me okay, can you?
I can, yeah.
And I can just about hear you, but if there is a problem with your microphone, I'll make sure that that I tell you.
Okay.
Just some standard base rules first about how we approach material considerations and appeal decisions. Appeal decisions, and there's plenty referred to in this case, are of course material considerations, but they're not binding on this inspector.
Yes, that's correct.
And I'll repeat to you the way that Mr. Village put it, I think on day one of this inquiry, where an issue is raised by a party, that doesn't necessarily make it a material consideration. It is for the inspector and her planning judgment to decide whether or not it is a material consideration and then afford weight to it.
Yes.
Now, with that in mind, I want to just think about rebalancing as a material consideration, please. You've been here throughout the inquiry and you'll have heard Mr. Mitchell's evidence where he agreed that rebalancing was a material consideration or is a material consideration.
Yes.
And Mr. Best presents one way of undertaking rebalancing, doesn't he?
Yes.
Because there's no policy setting out how rebalancing should be undertaken.
That's correct.
There's no guidance in PPG form about how rebalancing should be undertaken.
That's correct.
And insofar as the courts considered rebalancing in the quashed Worgs and Essington case, there's no legal judicial guidance on how rebalancing should be undertaken.
Not that I'm aware of, no.
What the courts did say, and it may be this is a matter for submissions, and if it is, please let me know, but what the courts did say is that where rebalancing is raised, it needs to be considered and decided whether or not it is a material consideration and then due weight given to it. So in essence, it was the error in the first case was a failure to give proper consideration to rebalancing. So this inspector must consider how she would choose to apply rebalancing, if at all.
Yes, I'd expect the inspector to make her own judgment on that based upon that context.
And Mr. Mitchell and Mr. Hodgson both accepted in their evidence that they didn't undertake a rebalancing exercise like Mr. Best.
Yes.
And they explained both in their evidence why they didn't think that they needed to do the same exercise as Mr. Best, didn't they?
They did, yes.
If you could pull up the Werg's appeal decision, please, and it's the second one that went in, H11A. Do you have that?
I think I might have a hard copy, just bear with me.
Yeah, no problem at all.
No, I haven't printed it off, but I can get it in front of me. Just yes, that's dated 31st of March 2021, isn't it?
Yes, that's the one.
It's addressed to Patrick Downs.
Yes.
Yeah.
At Harris Lamb. Yeah, if you scroll down to electronic page 60 of 121, if you're looking at it electronically, please.
Is this Appendix D you're referring to?
Appendix D, yes, just so we can see which part of the document we're in, and we see that this is the closing submissions on behalf of Dignity from Mr. Village. And then if you scroll down to page 64 of 121 electronically, page 51 as marked. And we've been through this already in the inquiry, but I just want to situate the point properly. Are you there?
Yes, yes.
Page 35, Mr. Village sets out Mr. Best's approach to dealing with, or how he undertook rebalancing in that case, which was to apportion 100% of cremations in the area to the new facility, and then he apportions 50% of cremations within the fringe area, the 12.9 minutes drive time outside the natural catchment area. You see that?
Yes.
Yes. Right. Good. So that was the way that the case was run at Werg's. I'd like you to go to page 24
of the document we're looking at.
24 of 121 of the document we're looking at, which is the inspector's report.
Yeah, I'm there now, yeah.
You there? And
oops. Mum, I'm just wondering whether we could have the paragraph. For those of us who are antediluvian and using paper copies, we just want to have the paragraph numbers, I think.
Yes, sorry, Mr. Village. Yes, of course. It's paragraph 5.12. So marked page 11 in the bottom, in the centre, bottom of the page. And I think
Yep.
Thank you. Do you have that, Mr. Williams? Do you have that, madam? We went there earlier in the inquiry, and this is where the inspector says that the dignity evidence was that its scheme would relieve Gornal Wood, and Westerly's updated need report forecasts a greater demand and consequential rebalancing, and notes that Dignity gave specific predictions for rebalancing while Westerly addressed this descriptively. Do you see that?
Yes.
And of course, it was Mr. Best in that appeal, and it was Mr. Best's specific predictions for rebalancing that the inspector is referencing there.
Yes.
If you could scroll down now, then please, to 13.4 of the inspector's report, electronic. So I'll say on the hard copy, paragraph 13.4, marked page 15, centre bottom of the page. Electronic PDF page 28 of 121.
Yes.
We see here the inspectors dealing with benefits and need. Assessing current and future use of crematorium is not an exact science. For example, the calculations of pressure on existing facilities were based on core slots. However, demand will generally increase and then decrease steadily over the course of the day. And so there was disagreement over which hours should constitute core slots. Neither the catchment areas for the works or Western scheme nor the method of determining them were agreed. And then the inspectors will say the WERG's use of a 50% figure for its fringe catchments. So that's a reference to Mr. Best's rebalancing approach, isn't it?
Yes.
Whilst not an unreasonable estimate, is little more than an educated guess.
Yes.
And it takes no account of quality and so is unlikely to be equally applicable to all crematoria. And then goes on to say that for Essington, the evidence of overlap relies more on an overall need in the wider area, on a much higher population nearby with rising death rates. This all illustrates the subjective nature of some of the assumptions behind the needs assessment. It does not mean that one is necessarily better than the other, only that they are different. Do you see all of that?
Yes, I can. Yeah.
So this is the inspector's summation of how the precise work of Mr. Best and the descriptive work of Westerly can be considered. And the conclusion sheet that the inspector appears to come to there is that they don't really say a great lot. It says that there's it just illustrates the subjective nature of the assessment and doesn't say whether one is better than the other. So it's perfectly open to this inspector to consider Mr. Best's approach and to consider the approach of Mr. Mitchell and Mr. Hodgson and conclude a similar situation, that one is no better than the other in interpreting rebalancing, isn't it? I can see a hand up. I'm expecting Mr. Village.
Well, I'm bound to ask, and of course, you know, I am admiring of this old advocate's trick of asking a witness who's nothing to do with this particular area questions upon which he's obviously not qualified to give answers. But I'm just bound to ask why it is that the learned friend didn't ask these questions of Mr. Best.
Ma'am, I'm flattered that Mr. Village considers me to be an old advocate.
No, it's an old advocate's trick.
An old advocate's trick. Oh,
yeah. No, you're obviously a learner.
The point that the reason I'm asking Mr. Williams of this is it's about the interpretation of an inspector's report. It's about a material consideration being rebalancing, and it's about how this inspector approached a material consideration, which is whether or not to choose one approach over the other. And Ma'am, it's the same. It's exactly the same approach, which Ma'am, I'll be inviting you to take in closing.
It doesn't go to the planning balance at all. If there was going to be questions about the way that should be given or attributed, or the inspector's views about rebalancing, those should have been asked of Mr. Best. In fact, as it was, Mr. Best said, I think twice during his evidence, that that his approach on rebalancing wasn't entirely accepted by the inspector. So, I mean, why didn't the learned friend pursue this point with him?
Well, that's right, Sorry, Ma'am.
I did wonder where the line of questioning was heading, I have to say, Mr. Robson, given that Mr. Williams is a planning witness and
yes,
not a witness for need.
Yes, ma'am, absolutely. I've no intention whatsoever to ask about the technical approaches to rebalancing and whether you should do it via Mr. Best's approach or by Mr. Hodgson's or Mr. Mitchell's, but simply to explore how the options open to you when you take into account which of the methods to apply, if you apply any of them. And Mr. Village is right that Mr. Best yesterday very fairly did say that the inspector didn't really accept his approach. He didn't find the evidence was behind it. I see Mr. Village is exasperated, not for the first time at me.
Honestly, don't take it personally, Mr. Robson. Madam, I mean, what Mr. Robson's just demonstrates how the point he wishes to the point he wishes to make can be made in submission. And effectively, he's just made the submission. He's going to be making closing, presumably. He doesn't need answers from this witness on that point.
Very well. Thank you,
I think I'd agree with that, Mr. Robson. So would you like to move on, please?
Happily. Paragraph 5.55 of your brief, please, Mr. Williams.
Yes.
Now, this is your proof, so we'll stay on this one. You say that the Department of Environment Guidance remains relevant and up to date for the purpose of selecting suitable sites for crematoria, and the DOE guidance has been accepted through appeal decisions as a material consideration for the determination of planning applications. My learned friend put it to Ms. Sudders as a slightly ancient piece of guidance. It may be old, but it's still, as you say, a relevant consideration for this inspector.
Yes, I think the inspector's entitled to look at that guidance, yes, as a material consideration.
Thank you. Could we go to it then, please, to F15? Sorry, F14.
Yes.
And it's paragraph 6, which says care is needed in the selection of a suitable site for a crematorium, and the local planning authority should be consulted at the outset. Now, you said in examination in chief, and I think it's written down in the planning statements accompanying the application, that the site assessment was carried out in November 2016. That's right.
Yes.
And so in November 2016 or thereabouts, did you consult with the local planning authority as per the guidance to find a suitable site for the crematorium?
No, we didn't. Not in 2016. We opened up the discussions with the local planning authority in 2019 when we'd gone through the exercise of finding a site, and we had a site to talk to them about.
And your planning statement, please, which you wrote and submitted as part of the application and is at CDB8.
Yeah, it was actually a colleague actually helped me to prepare this statement, but yeah, it is something I signed off.
You signed off, that's right.
I approved it, yeah.
And of course, the planning statement must be accurate and up to date and include all relevant evidence to support the application, mustn't it?
Yes.
Could you go to paragraph 6.3, please, which is on page 34. For the antediluvians and for the modern practitioner, 34 electronically and 34 on paper. Are you there, madam?
I have it.
You have it. Thank you. Sorry, I've given the. Sorry, forgive me. I've given totally the wrong reference. Sorry, that's absolutely my fault. It's your proof of evidence I want to be in, please, Mr. Williams. Sorry about that. It would inevitably be the one when the referencing was easiest, wouldn't it? That it would be my fault for getting it wrong. It's 6.3 in your proof of evidence.
Yes.
Which is on page 19 electronically and in hard copy. And it's the sentence we've already raised. However, as part of the very special circumstances case, it is appropriate to consider whether there are alternative preferable sites available to accommodate the development, and it's the tail piece within the catchment area it will serve. Do you see that part of it?
Yes, yes.
No, it's a. I assume that was the same approach that you took to the site selection in the planning application. That it is to accommodate the development within the catchment area it will serve.
Yes, because at the time we put in that planning application, we were looking at, or we were looking for, I should say, potential sites which could accommodate the crematorium development, with a particular emphasis on serving the needs of Doncaster, the Doncaster area.
But it's the role that the Western Arc plays, and the shift in the appellant's case, because it's now run in numerous documents that the relief to the Western Arc is the principal benefit of this scheme. So if the catchment is the Western Arc and relieving the Western Arc, then it follows from your approach to the site assessment that the search area would be within the catchment area for those Western Arc crematoria.
Yes, but don't forget, we're now going back to 2016, and you know, the position in terms of where that need needs to be satisfied has obviously changed, because since then a planning permission has been granted for the crematorium at Barnby Dun. So in terms of you know, what is the correct area to look at, once that decision was made, then we effectively reset our assessment of the need case, whether there was a need for a further crematorium in addition to Barnby Dun, and having looked at how that additional crematorium would relieve capacity issues in the Western Arc, then that was the change in focus.
And once Barnby Dun had been consented, obviously, of course, the context changes significantly, and Barnby Dun, as I think was agreed, would provide greater relief to Rose Hill than would your scheme. Was there then another site assessment done to see whether there was a site available to the west that would better meet the needs of the Western Arc?
Well, that assessment's been done through my proof of evidence. I have completed that assessment.
There's the assessment in your proof of evidence that looks to the west.
Yeah, you know, it's always difficult with these things, isn't it? As we've discussed, there's no manual or policy guidance which I can turn to help me as a planning consultant to complete an appropriate site search exercise. You know, there's no guidance to say should these exercises should be completed working to natural catchment areas, or 45-minute drive times, or 30-minute drive times. So we had to make a judgment, and the judgment then was that we look for the availability of alternative sites within the natural catchment area, which had been identified for me by Mr. Best's assessment of that need.
But I mean, that's the sorry, Mr. Williams, I didn't think you finished.
Yeah, sorry, I was just going to say, and I'm not sure, hypothetically, if we had looked further to the west, I'm not sure it would have been that helpful in terms of the outcome. Because if you look further west, again, you've got Greenbelt, which wraps around the urban extent of settlements which are west of the natural catchment area that I've looked at. No local plan. I know we're straying outside of Doncaster Borough now, but no local plans within those neighbouring administrative areas have an allocate land for crematorium. So I'm not convinced that if we had looked broader than the natural catchment area for alternative sites, that I would have found an appropriate site without encroaching on the Greenbelt.
Well, with respect, that's speculation, isn't it? Because there's nothing that you put before the inspector that says we looked further west to see if there was a site that would better relieve the Western Arc crematoria.
Yes, that's my judgment. That's my assessment. It is speculative because we haven't completed that exercise.
And in fact, you constrained yourself from the outset to not doing that, because if we look at the criteria.
So we're going back to 2016 now, is?
No, I'm not still in your proof of evidence.
Sorry. Yeah. Okay.
Well, if we look at the search area, so 6.8.
Yes.
You say natural catchment areas of existing and proposed facilities. It shows the natural catchment area for the existing crems, including the Barnby Dun scheme and the development. The NCA within which any given crematorium will be the most convenient has been defined by Chapter 10 of Mr. Best. I have sought to identify potential development sites for the development within the area shaded yellow, which covers the primary population who will be served by the development. So the question you've asked yourself is there another site within the area that we're already serving? Not, is there a site which can better serve the Western Arc?
That's exactly what I asked myself. Yeah. You know, I asked myself whether there is an alternative site within that general area which would serve the population that it's intended to serve in terms of a population that would find that the crematorium in that general location more convenient. It was on that basis that I completed the search for alternative sites to try to establish whether or not there was likely to be an alternative site which wasn't constrained by Greenbelt policy.
That's right, and there are two distinct points here, aren't there? There's one being a search for an alternative site that can serve the same area as your proposal, but perhaps isn't as constrained by policy. There's also whether you are searching separately, whether you are searching in the right location to meet the best meet the need that you say you are meeting. And they are two distinct points, aren't they?
Yes.
And so you've done the first part of that, which is to say, is there any alternative site that that can serve the same people that we're already serving, but not as constrained in policy terms? That's what you say you've done. Yes. But you haven't done that separate element, which is to respond to the context of Barnby Dun being consented and find whether there is a better site, Greenbelt or otherwise, that would better meet the need of those Western Arc crematoria.
Well, I think the first part of that is I think it does respond to the commitment that is now Barnby Dun, and the natural catchment area takes account of that. But yeah, you're right. I haven't looked at whether there are alternative sites further to the west, and the reasons for that I think I've hopefully explained to you. But again, just taking you back to the fundamental point here, which is that there is no point of reference, there is no guidance on how these searches should be completed. So in my judgment, this was the correct thing to do for the purpose of this inquiry.
But it goes to weight, doesn't it, Mr. Williams? Because you are asking for very special circumstances to be found on meeting the need of the Western Arc, and the Greenbelt test is a high one, and so the inspector should be satisfied, should she not, that granting a consent in the Greenbelt, this site is the product of a search to find the best available site to meet that need.
Yes, I think to be fair, you know, the needs case, it isn't wholly centred on the relieving capacity on the Western Arc. You know, there are other quantitative and qualitative benefits of the development. But you're right. You're right. I can't put in front of the inspector an assessment of what's available further to the west. I've tried to explain why I've completed the search exercise in the way I have. But what I can say, and it is speculation, I accept that, is that I find it surprising if we did look further to the west, whether we would find any suitable site which was not equally constrained by greenbelt policy. But I accept that is, I've got no evidence to support that contention.
So I just want to be clear, because it may be that I think I got the answer. I did. I'll put the question hopefully in a clearer way so that I can make submissions on it. You agree with me then that when the inspector comes to determining the weight to the need case, she should be satisfied, or she should look to satisfy herself that this site is the product of a site search to identify locations for the best available site to meet the needs of the Western Arc. I think you agreed with that statement. I just want to check.
Sorry, could you just repeat the last bit? I'm sorry.
So in order to meet need, the inspector, in order to determine the weight attached to need, the need case, the inspector should satisfy herself that this site is the product of a site search to identify the best available site to best meet the need of the Western Arc.
I think for the reasons I have set out, Mr. Robertson, I think that the inspector can draw a conclusion that this site is certainly the best site within the defined natural catchment area, and that no other suitable alternative sites beyond the greenbelt are available, and also that if the exercise was pushed further west, and I had gone out and looked at opportunities within the neighbouring Barnsley and Selby authorities, then it's unlikely that a better site beyond the greenbelt would also be available, in my view.
So unlikely, but no evidence to support that.
No, that's correct. Yeah.
Thank you. Greenbelt policy. The decision notice is CDA5 is clearly the author was knew my history teacher, and there is art in brevity. The proposal represents inappropriate development in the greenbelt for which very special circumstances have not been demonstrated. The proposal is therefore contrary to the Doncaster Core Strategy CS3 and ENV3, because ENV2 of course drops out, and the various paragraphs of the framework. What the decision notice is telling us, isn't it, is that the VSC test in paragraph 148 has not been passed.
Yes.
And so if you have the framework in front of you,
yes,
which is a core document, and paragraph 148. CDF 1 if you don't have a well-thumbed copy next to you.
Yes.
And it's the very special circumstances test is set out. VSC will not exist unless the potential harm to the green belt by reason of inappropriateness and any other harm resulting from the proposal. And it's the phrase any other harm. And you'll agree with me, and it's set out in case law, that any other harm includes any other harm to the green belt and any other non-green belt harm.
Yes.
Yes. And you'd agree with me as a point of principle that when you're carrying out your function as a planner, you can find that there is harm, but that level of harm does not necessarily cross a threshold to constitute a reason for refusal, a standalone reason for refusal.
Yeah.
But if it doesn't constitute a standalone reason for refusal, the harm doesn't disappear, does it? It's still a harm that must be weighed in the balance.
Yes, I'd agree with that. Yes.
So if, for example, there is landscape and visual harm, as Ms. Oxley found, and I know you disagree with it, but we've dealt with that already with Mr. Kirkpatrick to some extent. But if the inspector were to agree that there is landscape and visual harm, that would be weighed into the 148 balance as any other harm.
Yes.
Thank you.
And the inspector would obviously have to make a judgment on how much weight she attaches to that harm, having regard to all the other considerations.
And sorry, Mr. Williams.
Including benefits attached to the scheme.
Well, I mean, to determine the weight to the landscape and visual harm, she'd determine the weight to it and then weigh it against the benefits.
Yes.
Yes, she wouldn't do, I think the way that Mr. Village put it, she wouldn't infect the determination of weight to a harm or a benefit by carrying out a separate balance. In other words, you say, well, there's moderate harm to landscape and visual harm to which I attach significant weight. That goes into the balance and then may or may not be outweighed by the benefits. You don't say, I find moderate harm to landscape and visual. However, I think that on its own is outweighed, and so I'm not going to put it into the balance.
Yeah, I think they just to sort of think about that in a slightly different way. If the evidence seems to have been Mr. Village's.
Hello, Mr. Village.
Mr. Village.
I'm sorry to come in again, but I mean, I think my own friend's got to be rather careful here. I mean, he's treading on quite thin ice because, of course, his witness, well, the council's position is that you attribute substantial, and this is the view of his planning witness, Mrs. Sudders, that you attribute substantial weight to any harm, and you don't, in fact, give any grade to that harm at all. So I think I think my own friend ought to put or be clear, at least, as to what the council's case is. If he's going to, in sort of metaphorical terms, throw his witness under a bus here, then I think we ought to know. But I mean, I think he ought to be fair to the witness and say, look, this is what our case is. Because at the moment, I don't understand. I mean, Mrs. Sudders says that the gradation of the harm or the assessment of the harm is effectively irrelevant because it all should be attributed to substantial weight.
So I think we're talking at slightly cross purposes here. I was talking about the consideration of landscape and visual harm, which would fall into the 148 balance under any other harm. I take Mr. Village's point about greenbelt, weight to greenbelt harm, and we will deal with that in a moment.
Okay, thank you. Mr. Robson, do you want to move on?
Thank you. I mean, I think actually we're done about landscape and visual going in as any other harm within 148. But how we weigh greenbelt harm is directed by the framework, which tells us, excuse me, in 148, that local planning authorities should ensure that substantial weight is given to any harm to the greenbelt. So the starting position is any, it was plain, isn't it? Any harm to the greenbelt gets substantial weight.
Yes, you do give it substantial weight. Unless it's clearly outweighed by other consideration, it goes on to say, doesn't it?
Yes, and that's the balancing exercise, isn't it? But first, the inspector must determine the weight to give to harms to the greenbelt, and the policy is clear that it's any harm to the greenbelt, and we agree, don't we, that there is harm by inappropriateness. This is inappropriate development.
Yes.
So that would be any harm afforded substantial weight.
Yes, as I see it, there are effectively three elements, aren't there, of this, which the inspector should attach substantial harm to in the first instance, which is the definitional harm on the basis that it is inappropriate development because it's not a form of development which falls within the closed list at paragraph 149 of the NPPF. There should also be substantial weight attached to the harm in terms of the purpose of the green belt, which is encroachment. And I think this board, well, there is board agreement on that. And then the third element is substantial weight to any impact that might arise in terms of the openness of the green belt.
Yes.
And obviously the landscape and visual elements, assessment form part of that assessment of how it's going to impact on the openness.
Exactly, and I know there's a disagreement between us to some extent about openness, but I think it is agreed that there is a harm to the spatial element of openness.
Yeah, there is agreement. I'm not taking issue that the fact that we're putting a building on a piece of land that currently does not have a building on it. It's bound to have a spatial impact. But in the evidence that I produced, and also the evidence that Mr. Kirkpatrick, we've had it.
We lost you for a second.
Sorry, can you hear me now?
Mr. Williams, I think we got as far as the evidence that Mr. Kirkpatrick, and then
yes,
for me anyway, you cut out a bit.
Sorry.
No, it's not your fault.
So yes, the cause of the harm, if you like, is the spatial impact, because you're placing a building in the countryside which currently does not have a building on it. But then through evidence, we've looked at what is the effect of that spatial impact, and that you then look at the scale of the development, the extent of the development as and how it sits within its landscape, and from there we've drawn a conclusion that the impact on openness in this particular case is very low indeed.
But the inspector has the conclusions of Ms. Oxley, which were dealt with in Mrs. Suddy's re-examination, of the significant impact on openness, and of course Mr. Kirkpatrick's acceptance of a spatial impact on openness, but a dispute about the visual impact on it. What is agreed, though, is that there is a harmful impact on openness and a disagreement on the grading of that impact. I'm sorry, Mr. Williams. I think that was. I think that was correct, but I think all I heard was "ect." I missed the start.
Sorry, I do apologise if these headphones aren't working properly. So just to summarise the point, I think, which I made previously, I accept, and Mr. Kirkpatrick accepts, that there is a spatial impact, but the impact will be localised. And when all is said and done, the crematorium will result in a relatively small loss to the spatial extent of this part of the greenbelt.
So although there is a difference in grading, the inspector must attach substantial weight to the significant harm of Ms. Oxley, or must attach substantial weight to the more limited harm of Mr. Kirkpatrick, depending upon which she prefers.
Yes, it's appropriate to consider exactly what the extent of that harm is.
But the substantial weight remains the same, but it's substantial weight to a different grading of harm.
Yes.
So when we sum it up, and just to be clear, I'm not for one moment suggesting that this is some form of mathematical exercise. A bit like trying to get Mr. Best to descend into chaos. Oh, hello, Mr. Village.
Mr. Village.
So, can we be clear? The way that it's just been clearly put by my client to the witness, does that represent the council's case as to how this assessment should be undertaken?
Ma'am, I'm in a difficult position as my learned friend.
That's why I'm.
Mr. Sudders gave two different answers with respect to her to the inquiry. The first was that you give substantial weight to the grade of harm, which was in response to questions. I think that was yesterday, and a different answer today. My submissions will be on the basis of that first answer, that it is substantial weight to a grade of harm. I think professionally I might be in difficulty to do otherwise.
Yeah, okay. Well, that's very straightforward. I mean, characteristically straightforward response. Thank you.
Thank you.
Thank you, Mr. Robson.
So just to summarise then, Mr. Williams, the inspector will have to look at the harm by reason of inappropriateness, the harm to the purpose of the green belt, and the harm to the openness, attaching substantial weight to each of them, to each of the gradings of those particular harms.
Yes.
Thank you. I want to look then at benefits of the proposal, please, and addressing need. And this is linked to the site selection process. Would you agree with me that the inspector needs to follow a two-stage approach? The first is to identify the level of need and its location, and we can agree that there is overtrading in the Western Arc.
Yes.
And then to assess the scheme's ability to meet, and then assess the level at which this scheme meets that need and whether the proposal is best located to meet it.
Yes.
Thank you. And when looking at stage one, identify the level of need and its location. As I've said, we agree that there is overtrading in the Western Arc. If, when the inspector were to come and to look at Rose Hill, she were to conclude that there is overtrading, but there is no overtrading, or there is limited overtrading after Barnby Dun and after Retford, that would reduce the weight that can be given. Well, sorry, now let me get this. If it is trading at under 80%, as Mr. Mitchell put out in his further evidence, post Barnby Dun and post Retford, then there is, using the 80% rule of thumb, no need with regard to Rose Hill.